Hi, I'm Rudolf du Plessis. I'm a partner in the corporate department of Bowman Gilfillan. We, in the corporate department, regularly use preference shares as funding and other funding and other structures. And for that reason, preference shares is something that's very important for us. And it will be, the position in regard to preference shares will change under the new Companies Act. And I'm going to talk for a few minutes just about preference shares and the treatment of preference shares under the new Companies Act. Preference shares, although they looked at from different points of view, from a company law point of view, preference shares are proper shares in the capital of the company, and therefore from a company law point of view are treated as such. Preference shares under the current Companies Act have got much less flexibility in how they can be structured than under the new Companies Act, and I'll just deal with the two most important issues. The new Companies Act specifically provides that you can have shares and that you must set out the rights and preferences applicable to those shares in the Memorandum of Incorporation of the company, and that's how it would work. Where it differs from the position under the current Companies Act, the current Companies Act regulates specifically when preference shareholders can vote, and regulates in the Companies Act how they can vote, and those are therefore specifically set out. When they can vote, and broadly what that means is that preference shareholders can vote to the extent that their rights are affected or to the extent that the preference dividends are in arrears. Under the new Companies Act, there's no such regulation, and basically all that it says is that preference shareholders will only have a vote, or it's possible to structure a preference share so that it will only have a vote in the event that there's something that is done that materially adversely affects the rights of the preference shareholder. So that's the one area where there's a big difference between that position and the position under the current Companies Act. The second issue relates to dividends, and to a large extent dividends will be regulated in the same way as under the current Companies Act, and the terms of the dividend would be set out in the Memorandum of Incorporation, which is the new constitutional document of the company. The last area which is different from the position under the current Companies Act is that the new appraisal right, which is basically a right that allows a shareholder to force the company to buy that shareholder out, that appraisal right will also attach to a preference shareholder, which obviously is a big difference and something that needs to be looked at, because that means that a preference shareholder can at any time require the company, or in certain circumstances require the company, to buy back that shareholder's preference share at the market value or the fair value in respect of those shares, and that position is different from the position under the current Companies Act, where a preference shareholder can only in certain circumstances require the company to redeem the preference share. Under the new Act, if the requirements in respect of the appraisal right are met, then it means that the appraisal right would be applicable to the preference shareholder. Thank you.